Let me ask you something. Imagine you are driving to work. You get pulled over for a minor traffic stop, maybe a broken tail light, maybe you forgot to signal, and within minutes, you are not getting a ticket. You are getting arrested. Not because you did anything seriously wrong, but because of who you are and where you were born. This is happening right now across the United States, and if you or someone you love is an immigrant, this video could be the most important thing you watch this year. Welcome back to US Visa Explained, the channel where we break down the real immigration rules, the real laws, and the real situations that affect your life in this country. If you are new here, make sure you subscribe because we cover things that most channels are too afraid to touch. Today, we are going deep into the 10 driving law changes happening in 2026 that every immigrant, every visa holder, every green card holder, and every undocumented person needs to know about right now before they get behind the wheel. This is not about scaring you. This is about protecting you with knowledge, because what you do not know can absolutely destroy your life here in America. Let us start from the very beginning and understand why driving laws and immigration enforcement are now connected in ways they never were before. For decades, a traffic stop was just a traffic stop. You get pulled over, the officer checks your license, maybe writes you a ticket, and you go on with your day. Immigration status was rarely part of that conversation. Local police departments had what were called sanctuary policies, meaning they would not ask about your immigration status or report you to federal immigration authorities. That world is quickly changing in 2026. The first major change you need to know about is the expansion of 287 green agreements between local law enforcement and federal immigration authorities. In 2026, hundreds of new sheriff departments and local police agencies have signed or renewed these agreements, which officially give local officers the power to act as immigration enforcement agents during routine stops. This means the officer who pulls you over for speeding is no longer just a traffic cop. In many counties and states, that officer now has the legal authority to check your immigration status and hold you for federal pickup. This is a dramatic shift from just a few years ago, and if you live in a state like Texas, Florida, Georgia, Arizona, or Ohio, the chances of encountering an officer with 287G authority have increased significantly. The second change involves driver's license requirements and how they are being used against you. Several states in 2026 have passed new legislation that restricts undocumented immigrants from obtaining driver's licenses, reversing progress that was made in previous years. At the same time, states that do allow undocumented immigrants to get licenses, like California, New York, and Illinois, have passed laws protecting that information from being shared with federal databases. But here is the catch. If you are driving in a state that does not recognize your license, even if it is legally issued in another state, you can be charged with unlicensed operation, and that charge can trigger a deeper investigation into your status. So if you hold a license from California but you are visiting or temporarily living in Florida or Texas, you need to understand the local rules of that specific state. The third change is something called Real ID enforcement at traffic stops. In 2026, the Federal Real ID Act is being enforced more strictly than ever. While it was originally designed for airport security and federal building access, law enforcement is now using Real ID compliance as a tool during traffic stops. If you present a non-compliant ID during a stop, officers in certain states are trained to flag this and follow up with additional questioning. For immigrants who hold state IDs that are marked as limited purpose or not for federal identification, this is a huge red flag that can trigger secondary questioning about your status. The fourth change is about vehicle checkpoints. In 2026, Border Patrol has significantly expanded the radius in which they operate interior checkpoints. While the law technically allows checkpoints within 100 miles of any U.S. border or coastline, many of these checkpoints had been scaled back under previous administrations. Now they are back in full force, and in some cases being set up in areas that are far from traditional border zones, but still fall within that 100-mile legal limit. Roughly two-thirds of the U.S. population lives within this zone, including major cities like New York, Los Angeles, Chicago, Houston, Miami, and Seattle. If you live in these areas or near a coast, you are in a zone where a checkpoint can legally stop your vehicle and ask about your citizenship status without any specific reason or suspicion. The fifth change involves the use of license plate reader technology shared between local police and ICE. In 2026, a growing number of law enforcement agencies have begun sharing their automated license plate reader data directly with immigration and customs enforcement. This means ICE does not even need to wait for you to make a traffic violation. They can track the movement of a vehicle registered to someone on their radar, alert local police when that vehicle is spotted, and coordinate a stop based on your location patterns. This is a form of surveillance that most people do not realize is already being used, and it is expanding rapidly this year. The sixth change that is catching a lot of immigrants completely off guard involves the consequences of driving under the influence for visa holders. This has always been a serious issue, but in 2026, the processing of DUI charges through the immigration system has become faster and more aggressive. Under current policy, even a first-time DUI can be considered a crime involving moral turpitude or evidence of a substance abuse issue, both of which can trigger visa revocation, green card denial, and removal proceedings. What used to take years to reach an immigration judge is now being processed in months, and in some cases, weeks, thanks to new interagency data sharing agreements. If you are on an H-1B, an F-1, a green card, or any other immigration status, a DUI in 2026 is not just a traffic problem. It is potentially the end of your life in the United States. The seventh change affects hit-and-run cases specifically. In several states, new laws passed in 2025 and taking effect in 2026 have upgraded the penalties for leaving the scene of an accident, and immigration authorities have been instructed to treat hit-and-run convictions as high-priority deportation cases. For undocumented immigrants especially, the fear of stopping after an accident because of potential ICE contact has tragically led some people to flee, only to face far more serious consequences later. The new laws are designed to address this by creating legal safe harbor reporting systems in some states, but in most states, the message from enforcement is clear. A hit and run will be treated as a criminal matter that directly feeds into immigration proceedings. The eighth change involves how minor traffic warrants are being handled. In the past, unpaid traffic tickets or missed court dates on traffic violations were handled locally and rarely crossed over into immigration territory. In 2026, several states and counties have connected their traffic warrant databases with federal immigration systems. This means if you have an outstanding warrant for something as minor as an unpaid speeding ticket and you get pulled over, officers can now see that warrant flagged alongside immigration enforcement alerts. What begins as a routine stop can escalate to a hold and then a federal detainer. Many immigrants who have been in this country for years, working, paying taxes, raising families, are now being swept up because of old minor traffic infractions they did not realize were sitting in the system waiting to be discovered. The ninth change is about what happens after you are detained during a traffic stop. In 2026, the legal window that local law enforcement can hold someone on a federal immigration detainer has been extended in many jurisdictions. Previously, many courts had ruled that holding someone beyond their normal release time based on an ICE detainer was unconstitutional unless it was accompanied by a judicial warrant. Several new state laws have worked around this by creating specific statutory authority for these holds, meaning an officer can now legally keep you detained even after your traffic matter is resolved while waiting for ICE to respond. The key thing to know here is that you have the right to remain silent about your immigration status. You are not legally required to answer questions about where you were born, how you entered the country, or what your visa status is. Exercising that right respectfully and clearly is one of the most important things you can do to protect yourself in this situation. The 10th and final change is perhaps the most sweeping of all, and it involves a new executive level directive that instructs all federal agencies, including those involved in transportation and infrastructure, to treat immigration enforcement as a shared responsibility. This means that in 2026, everything from Highway Patrol to Department of Motor Vehicles interactions has been influenced by this directive. Agencies that previously had nothing to do with immigration are now being asked to report suspicious activity, flag certain documentation issues, and cooperate with ICE in ways they never did before. The practical impact of this is that the entire system of driving and vehicle operation in America has become, for immigrants, a potential point of contact with immigration enforcement. So, what do you do with all of this information? First, you stay calm and you stay informed. Knowledge is your most powerful protection. Second, you know your rights. If you are stopped by police, you have the right to remain silent. You have the right to refuse consent to search your vehicle. You have the right to ask if you are free to go. And if you are not free to go, you have the right to an attorney. Third, you carry documentation that is appropriate for your status. If you have valid immigration documents, travel permits, or visas, carry them and know what they mean. If you are undocumented, speak with an immigration attorney about what you should and should not carry. Fourth, you drive carefully and legally. This sounds simple, but it is the most powerful prevention tool you have. Obey traffic laws, maintain your vehicle, keep your registration and insurance up to date, because the less reason an officer has to stop you, the safer you are. And finally, do not face this alone. Share this video with your family, your friends, your community. The more people who understand these changes, the more lives can be protected. Immigration law is complicated, it is changing fast, and it is deeply personal. But you are not powerless. You are not alone. And as long as channels like USA Visa Explained are here, you will always have someone breaking it down for you in plain language. If this video helped you, please give it a thumbs up. It genuinely helps us reach more people who need this information. If you have questions about your specific situation, drop them in the comments and we will do our best to address them. And if you have not subscribed yet, do it right now, because the next video we are releasing is about the 5 documents every immigrant should carry in their car at all times in 2026. And that is a video you absolutely cannot miss. This is USA Visa Explained. Stay safe, stay informed, and we will see you in the next one.